want to be candid here. Your client absolutely has a right to invoke his Fifth Amendment right. However, given the circumstances of this case, I myself am constrained to make a bar complaint. All right, let me call page 3. This is case number 822-846-652C, National Default Servicing Corporation versus Jerald Wheat et al. Could I have appearances, please?
Good morning, Your Honor. Chris Connell on behalf of Eva Wheat.
All right, good morning, Mr. Connell.
Greg Wilde, bar number 4417, here on behalf of Scott MacDonald.
Okay.
MacDonald is president of the courtroom.
Good morning to you both. Let me ask you all. My order to show cause was for the parties to also appear, so I know you represent one party. Mr. Connell, where is Miss Wheat?
Miss Wheat's an elderly woman. She's 80 and she's difficult to get around. Wasn't prepared to have a waiver for it. Jerald Wheat is 90 and lives in California. So
You do not represent Mr. Wheat though, right?
I don't. I sent him via runner an actual engagement. He has it, but I don't have it back. He doesn't have the internet. He doesn't have a cell phone. He doesn't have, a computer.
Okay. Mr. Connell, just for future reference, had you made a request for Ms. Wheat not to appear, I most likely would have granted it under the circumstances, but I expect those requests to be made in advance.
Understood, Your Honor. My
Okay.
apologies.
Very good. Okay, so we are here today, folks. I think I set it forth pretty well in my order of January 22nd, 2023. About the history of this case. So this is an interpleader action. There were about $80,000 of funds interplayed, which I assume was from some type of foreclosure sale by National Default Servicing Corporation. In June of 2022, 6 months passed, Mr. MacDonald made an appearance on behalf of the only 2 named defendants, Jerald and Eva Wheat. He made a motion to disperse. In deciding that motion, I initially granted it because there were only 2 defendants named by the interpleading plaintiff, and so I saw no reason not to grant the motion. After issuing the order, my law clerk got, I believe, an email communication from Mr. Connell almost immediately as soon as the order was issued, saying that Mr. Connell had said in the email Mr. MacDonald was not the attorney of record for the distribution of funds, and was never retained by either Jerald or Eva Marie Wheat. And in fact, Mr. Connell was retained by Eva Marie Wheat and enter a substitution into the case, even though it was filed into the case without without the knowledge or permission of the defendant. Accordingly, the court, and I want to be candid, and this is in my order as well. I also, because of the circumstances of this, I asked Mr. Connell to call me. Because it was after business hours, I wanted to make sure that the funds were not improvidently distributed as early as Monday morning. We had a very short conversation, but what he said to me on the phone was that he had spoken with Mr. MacDonald, and Mr. MacDonald had admitted to him that he had never been retained by either of the 2 defendants. Court's obviously troubled by this. This is why we're having the conference today, to clarify everything. So I'm going to start, because this started with Mr. Connell's email and then our subsequent phone conversation, I'm going to allow Mr. Connell to put on the record the information that he is aware of, and also given that he is attorney of record for one of the defendants, Eva Marie Wheat.
Thank you, Your Honor. I received a phone call from Eva's grandson, Franz. He was alerted that there was this action. He said they had never retained anybody for this matter. So I looked into it. I saw that Mr. MacDonald had filed into this case saying he represented both. I clarified with them that they had not retained anybody. We were having trouble getting a hold of Jerald Wheat. He had been served by mail, and that's how he had known of it, or whatever. That's how he had responded initially. So then I immediately sent an email to Mr. MacDonald's office saying, hey, do you represent this party? Because I didn't know if I was doing a substitution. Could have been my error. I didn't know if maybe they just didn't remember hiring him. They said, Mr. MacDonald called me immediately, let me know what happened, and I was obviously troubled by what happened. So I was told by Mr. MacDonald that this was the first time it had ever happened, that it was a bit premature, jumped the gun, that the plan was to file and get the money, hold it in trust, and then try to find them later. And I went, that's not a proper way to do things. Said it was the first time ever, check me out, no complaints against my record. I'll substitute you out, you can take it over. Immediately signed over a substitution of attorney. So out of my own natural curiosity, I looked it up. I found personally multiple cases where this has happened before. And after a 10-minute Google search, I found a couple of the parties who said, I've never hired anybody for that case. I didn't know I was owed funds. I have a couple on my phone right now. I under no circumstances thought I was entitled to anything. A lot of people who don't know that after foreclosure, if there are excess proceeds and after the first lien is extinguished or paid off, they're entitled to those proceeds. But a lot of people don't understand their rights, they don't show up, they're not represented by counsel, so those funds just go into the ether. So it's my understanding that that's happened in multiple times, and I have case numbers, I have whatever, and I looked at it and I said, this puts me at a serious quandary what to do. I don't want to be in this position. No attorney wants to be in this position. We're a self-governing, organization. We work hard for our licenses, and we have to hold up a standard. So I called the anonymous bar counsel. Hey, what do I got to do here? We went through exactly what it was, and I was told that it's a mandatory complaint, basically, based on the steps. Is this someone in the community that's done this before? Has this been repeated? What is the situation here? So that's where we're at, Your Honor. So when I saw that order coming in, we had a hearing scheduled for the next week. That put me in a panic mode because I'm going, wait a minute, this is going to come out next week. If it went through, I did what I felt I had to do. If it went through and the funds were distributed according to how they should be to this week, then we could move on from there. But you caught the order on a Friday night and saw it. We had a call, and that was disclosed, the ex parte communication in your order, and that's where we are today. So.
All right, thank you very much, Mr. Wilde.
Yes. Excuse me. Yes.
Would you like to say anything?
Not simply that I represent Scott MacDonald today. He hired me to be here with him today, and here I am.
Do you have a response to what Mr. Connell has? Well, here, the question is, and I feel like I do have to say this, right? Because these allegations are very serious, and so I don't know if you have advised your client whether or not he should speak. But one thing I want to know is what Mr. Connell's saying is true.
Your Honor, I don't know anything about, I've never met Mr. Connell. I hear him today. I read the court's order. I didn't do any independent research into any other matters, simply this case. And yes, I've advised my client today that he should invoke his Fifth Amendment rights and not say anything.
Okay, so you are neither confirming nor denying whether or not your client ever represented Eva Maria or Jerald Wheat. Is that correct?
That's correct, Your Honor.
Okay. I want to be candid here. Your client absolutely has a right to invoke his Fifth Amendment right. However, given the circumstances of this case, I myself am constrained to make a bar complaint. I want to be candid that is going to be forthcoming. It is not within the purview of this court to undertake its own investigation as to the other cases that Mr. Connell has alleged that Mr. MacDonald has undertaken similar actions. This is what I should say. I assume Bar Counsel will be doing that if and when they review Mr. Connell's complaint and if and when they see the report that I make. One thing that I am constrained to do here is I am going to institute an order to show cause for why Rule 11 sanctions should not be applied. And looking at Rule 11, and I'm going to pull it up so I read it correctly. Rule 11B provides that by presenting to a court a pleading, a written motion, or other paper, whether by signing, filing, submitting, or later advocating it, an attorney or unrepresented party certifies that to the best of the person's knowledge, information, and belief formed after an inquiry reasonable under the circumstances, that it is not being presented for an improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. 2, the claims, defenses, and other legal contentions are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law or for establishing new law. 3, the factual contentions have evidentiary support or if specifically so identified will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. And 4, the denial of factual contentions are warranted on the evidence or if specifically so identified are reasonably based on belief or a lack of information. The court finds that a prima facie case has been made here today that Mr. MacDonald has violated Rule 11B 1 and 2 at the very least. Accordingly, the court invokes its powers under Rule 11C 3, which provides that on its own, the court may order an attorney, law firm, or party to show cause why conduct specifically described in the order has not violated Rule 11B. Accordingly, the court sets a show cause hearing for March 1st at 9 a.m. for Mr. MacDonald to show cause why Rule 11 sanctions should not be imposed on him. Okay, thank you very much, everyone.
Thank you. Your Honor, the status of the distribution, I just want to be able to tell them. Do we need to file a motion or something, or is there going to put it on hold, or?
Thank you for bringing that up. So this is what we're going to do. Given that Mr. MacDonald cannot confirm whether he represents either defendant, well, he clearly doesn't represent your client, Mr. Connell, because there's a substitution. But
Right.
given that he cannot confirm whether he represents Jerald Wheat, I'm putting an order in that says that he does not represent Jerald Wheat. Accordingly, Mr. Wheat is going to be unrepresented in this case. If you would like a distribution, make a motion.
Understood, Your Honor.
Very good. All right. Thank you, everyone.
Thank you.